If you got hurt on someone else's property, do you have to pay for your injuries? Premises liability is a legal concept that holds property owners responsible for accidents and injuries that occur on their property. But what does that really mean? And how does it affect you, whether you own the property or you're simply visiting? My name is Megan Shaw, and I'm a personal injury attorney with Parrish and Goodman. We help people all throughout the state of Florida receive compensation for injuries they received through no fault of their own. First, let's talk about responsibility. As a property owner, you have a duty to maintain a safe environment for anyone who steps foot on your premises. That includes customers if you own a business, guests at your home, and even people who are just passing by. If someone is hurt due to unsafe conditions, you could be held liable. Now, not every accident leads to liability. There are a few factors courts consider when determining if a property owner is responsible. Was the injured person invited onto the property, like a customer or a social guest? Or were they trespassing? Property owners typically owe the highest duty of care to invited guests and a lower duty to trespassers. Another important factor is whether the owner knew or should have known about the hazardous condition. For example, let's say a spill occurs in a grocery store. If the store employees knew about the spill and didn't clean it up in a reasonable amount of time, the store could be liable if someone slips. But if the spill just happened and no one had a chance to address it, liability may not apply. There's also a concept of open and obvious dangers. Property owners may not be liable for injuries caused by hazards that are easily seen or expected, like a tree root sticking out of a landscaped area. It's reasonable to assume that visitors should take care when navigating such conditions. On the other side of things, if you're the one visiting a property, it's important to understand your own responsibility. You can't ignore obvious risks or act recklessly. If you're aware of a danger but proceed anyway, you may not be able to recover in the event of an injury. In a recent case of mine, I defended a previous client who owns a business that had a claim brought against him for someone tripping in a landscaped area. However, it was an open and obvious condition. It was a tree root in the middle of a grassy area. The person who was walking should have seen what she was walking over. The court actually agreed with me and determined the condition was so open and obvious that the business owner was not responsible as a matter of law. Normally, I handle the opposite side. I'm a plaintiff's attorney, but it was a former client who owned the business, and he definitely wasn't liable for an open and obvious condition. To sum it up, premises liability is about balancing responsibility. Property owners must take reasonable steps to keep their property safe, but visitors also have a duty to look out for their own safety. If either party neglects these duties, legal consequences can follow. If you were injured on someone else's property, you have rights. Schedule a time to meet with our team to review your case and get all of your options. There is no cost for speaking to us, and if we cannot win your case, we will tell you up front. If the case has merit, we will take it on, but if it doesn't, we won't. Contact Parrish and Goodman today.